Hi, my name is Marla Neufeld. I'm a reproductive attorney licensed in Florida and former intended parent. So people like to know what typically goes into a surrogacy agreement. First of all, you have to take a step back and analyze which state law are you doing your agreement under, because every state has different laws regarding surrogacy. I'm licensed in Florida, and my general rule of thumb is you use the state law of where the surrogate is giving birth for the law of the contract taking place and where the parentage legal proceedings will be taking place. So once you've evaluated what the state law is going to be for your agreement, then within the agreement, we will reflect that state law for what the parental rights will be, the court process to make sure the intended parents are named as the parents on the child's birth certificate, and to ensure that any parental rights of the surrogate will be terminated and making sure she doesn't have any parental rights to the child. So setting aside the parental rights issue, which is hugely important, a surrogacy agreement addresses many different topics. A typical agreement can be anywhere between 50 plus pages, but it'll have the payment terms between the intended parents and the surrogate. It'll talk about certain things such as, is she getting a life insurance policy? How much does she make for her base amount? How much does she get paid if she has to have a C-section or has a twin delivery? What health insurance the parties are using for the pregnancy expenses? Who's paying the premiums for that insurance that the surrogate will be using, and making sure it's clear that the parents are financially responsible for any uncovered medical expenses for the surrogate and any medical expenses of their soon-to-be child. The contract also goes into certain things like how many embryo transfers the surrogate's willing to do, how many embryos are going in per transfer. There's certain confidentiality provisions, making sure that the identity of the parties is not shared with anybody that's not required or unless otherwise agreed by the parties. The agreement will also reflect that, especially within Florida, I know we have certain provisions that have to say that medical decisions that relate to the surrogate's body are the surrogate's decisions to make. So it has to be clear that while the surrogate may agree to do or not do certain things relating to the pregnancy, such as have an abortion or do a reduction, the ultimate decision for issues like that do lay with the surrogate, even though the contract may address certain breach provisions if she violates what she's committing to do. So it's very important that before you embark upon a surrogacy arrangement, that you contact an attorney who specializes in reproductive law in the jurisdiction where the agreement will be taking place, so you can understand what the laws are regarding surrogacy. Some states don't have laws, some states it can still be illegal, some it's very permissible. So to understand what your state laws are and understand what the contract will look like and what the process will be like, and to engage your attorney as you approach medical and psychological approval so that you're ready to go and there won't be any delay for the legal process when it's time to proceed with that. If you have any questions, please feel free to reach out to me. My phone number is 954-761-2929. Thank you very much.